Greetings law fans, thanks for joining me again on my video blog. Today we're going to talk about minor settlements. And when I say minor settlements, I don't mean small settlements or minimal settlements. I mean injury settlements for injury claims for people who are technically minors under our definition of that, meaning they are underage, which means they don't have necessarily the powers that adults would have under the law. In our state, for these purposes, that age is 18. So, here's the thing. In our state, if you're under the age of 18, you aren't able to enter into a contract, which means that you can't really settle your own injury claim if you're under 18. So somebody has to do it for you. Well, the problem that you can run into in this situation is, let's say a parent has a child who has an injury claim. Child is, of course, under 18 for this illustration. And they have this injury claim, and the parent says, okay, well, we'll settle it for X amount. They settle it, there you go. The problem that arises with that is that if, when the child turns 18, he can come back to mom and dad and say, hey guys, you know, my knee still hurts from that accident that happened over how many years ago, and you guys settled it, and where's my money? And by the way, even if you do have the money, which you probably don't, you probably spent it by now, I don't think that was enough. I don't think that was in my best interest. And so I'm going to go after you, parents. I'm going to go back after the tortfeasor, the person who caused the accident in the first place, or was responsible for the injury. I'll go after the attorney who represented you and everybody involved, and the insurance company too. And they can do that. That's the problem that comes up in these situations, whenever you try to settle a claim for a minor, when you don't necessarily have the power to do it. Well, in reality, with relatively small claims, and I'll tell you what relatively small means in just a moment, we tend to let it go. The theory is that for smaller claims, the damages aren't going to be long-lasting. They're not going to really last until the child is 18 or after. And as a result, there's going to be so little money involved, and such a low likelihood that the child is going to have any lasting effects or have any need to make such a claim as I described against the parents and the attorneys and the insurance companies and so forth. So we tend to let them go, and for the most part, that's how business works, and it's okay. It's a risk still because the child can always come back, but for the most part, it's a calculated risk, and it tends to work out in everybody's favor. Now, if you want a more finalized settlement, a more, let's say, powerful guarantee that things are done and there's no way the minor, even whenever he or she reaches adulthood, is going to be able to come back and get you, then you might have to do what's called a judicial approval of the settlement. Now, I talked earlier about what a relatively small settlement would be, and those that are below that threshold tend to just get handled by the parents or whomever. For the ones that are above that threshold, we ask for judicial approval with the courts. Now, who draws that line? For the most part, we really let insurance companies draw the line, although sometimes plaintiff's attorneys, such as myself, and sometimes parents will want to initiate that judicial approval process. But as I say, for the most part, the insurance companies tend to draw the line because, as I explained to you earlier, you don't want to have the minor be able to come back and get more money on top of whatever it is that you paid for them. You want finalization. That's the whole point of settling the case. Everybody does. Insurance companies vary on the lines that they draw. Some say anything over $2,000. Some are between $2,000 and $5,000 as the minimum number. Some have things over $5,000, some over $10,000. It just depends on the insurance company and sometimes the individual adjuster. And of course the case too, maybe a case-by-case sort of analysis. But let's say that you have something that's going to be over whatever that threshold amount is, and all the parties really want to seek a final, firm adjudication of the matter so that it's not going to come back and haunt anyone. So what do? Glad you asked. That's why I'm here. Remember that a minor can't enter into a contract. Well, by the same rule, a minor can't authorize someone to file suit on his behalf or decide to file suit on his or her behalf. So in that situation, you have to have what's called a guardian ad litem. That person is going to represent that minor's legal interests. And that person is appointed by the clerk of court by a not terribly complicated process, but a process nonetheless. Once the guardian ad litem is appointed, then the guardian ad litem is going to be authorized to file suit on behalf of that minor. Now, you have to file suit in order to get the minor settlement approved, or you have to initiate some proceeding before the court so that the court has something there in front of it, something before the court, so that the court can make a ruling on it. Without a claim being filed or some proceeding, some special proceeding set up, the court doesn't have anything to rule on. So you have to initiate what we call a friendly suit most of the time. It's friendly in that everybody knows what's going on. Normally the plaintiffs and the defendants have agreed, the guardian ad litem has said, yeah, I think that's an okay settlement for my minor client. Parents are on board, everyone's on board. Hopefully the child is on board too, but the child may or may not have sufficient capacity to make that decision. We don't know. But most of the time you're in a situation where all of the parties are in agreement as to what the case should settle for. So you file the friendly suit, you put it before the court at a hearing, and the judge hears what you have to say about the terms of the settlement. Most of the time, the court is going to agree to it unless there's something that the court just doesn't feel comfortable with, but we won't talk about those right now. We'll just talk about the ones that do get approved because they're by far the majority. The court approves the settlement, and at that point it becomes a court order. The case is settled. It's done. It is res judicata, and it can't be the matter can't be relitigated or opened again. There are lots of issues that can come up between the beginning and the end of a minor settlement, though, that a lot of people don't really even consider until they get into this, and sometimes not until afterwards, and that can raise some problems for them. Two of the main ones would be that a lot of people don't understand that a minor's injury claim is separate and apart from the parent's claim for the minor's medical expenses. Those are two separate claims, and they actually have two separate statutes of limitations, or they begin to run at certain times. So you have to bear that in mind whenever you're timing the filing of this, and sometimes you want to have the parent assign that medical expense claim to the child so that the child can get the benefit of that part of the settlement. There's also, in many circumstances, a Medicaid issue with a minor settlement. Minors that are on Medicaid at the time of the accident, you'll often have to make sure you pay back Medicaid from the settlement. And you have to know what amount Medicaid is going to be entitled to recover in that situation. And also, you want to make sure that after the settlement, if the child is still going to be on Medicaid, that you want to maintain that minor's eligibility for Medicaid. If the minor has $2,000 or more in liquid assets that are available to the minor, then they can lose their Medicaid eligibility. That being the case, you have to take certain measures, normally a special needs trust or something like that, to make sure that you're going to maintain the child's eligibility. What a lot of people don't also understand is that once the case is settled, the funds that are going to go to the minor don't actually go to the minor. You don't want to give a 5-year-old $40,000 because that's a lot of candy. But at some point, the money is going to go into some safe haven. The clerk of court is typically the default option, but you can also set up some sort of trust to administer the funds for the child, and the child will have some limited access, depending on the terms of that situation, to the funds. And at some point in the child's adulthood, be it 18 or maybe some other age, depending on the terms of the trust, then the child will have either unrestricted or slightly restricted access to the funds, depending on the terms. Interesting stuff, huh? So it can get complicated, which is once again yet another reason to call a personal injury attorney when you have a situation like this. Hope you've enjoyed this, hope you've learned something, and I appreciate you coming. Thanks a lot. I hope you noticed the little coffee sleeve that my wife got me. Isn't that lovely? I like it. She's awesome. Good stuff. Thanks, guys. See you around.